Case number 241844, which is Qube Hotel Iowa LLC, Appellees and Cross Appellants versus Lotus Hotel Group LLC, and Cheaton Patel Appellants Cross Appellees. And by my notes this afternoon, we have counsel, let's see, who do we have over here? Do we have Ms. Abby Furlong? All right, representing Qube Hotel, and then we also have Mr. Matthew Sease representing Lotus Hotel Group LLC, correct? All right, very good.
I'm representing Qube Hotel.
Oh, Qube Hotel. All right, well, we actually have this backward on our docket sheet here. We will get that fixed. All right. All right. At this time, Ms. Furlong, you're ready to proceed?
Yes, Your Honor.
All right.
Please the court, counsel. Good afternoon, Your Honor. My name is Abby Furlong, and I represent the appellants cross appellees in this case, which involves a dispute over a failed business transaction centering on the Qube Hotel located in Polk City, Iowa. We're here today because the hotel's real estate holding company, Appellant Lotus, and one of its members individually, Appellant Cheaton Patel, were held liable for a debt owed by a separate entity, the unnamed party, or the unnamed entity, Shri Hotel Management Company, which is the operating entity for the Qube Hotel. Now, yes.
Error is preserved on the question of whether that third, or I guess fourth, really entity is who should be liable at the end of the day.
And this is something that we addressed in our, it was a bench trial, we addressed it in our closing briefs, which the parties did in lieu of closing arguments. We do believe this was considered by the court, which is what's required for error preservation, that an issue be submitted to the district court and that it be ruled upon. It was clearly ruled upon.
Where do you think the district court ruled on it?
We believe the district court ruled on it when it ruled in favor of appellees on the unjust enrichment claim. So that argument was a defense to the unjust enrichment claim, essentially saying they have not proved what they needed to prove as to the named defendants.
Was Shri's liability pled as a defense to that claim?
It was not pled as a defense, no, but I do think that that shifts the burden onto the defendants. Now, there was some passing reference to whether Shri was an indispensable party, and I do not believe that is the case here. If we look at Iowa Rule of Civil Procedure 1.2342, it defines a party as being indispensable if the party's interest is not severable and the party's absence will prevent the court from rendering any judgment between the parties before it, or if notwithstanding the party's absence, the party's interest would necessarily be inequitably affected by a judgment rendered between those before the court. Now, this is a protection for the party that has not been joined to the action. It is not a protection for the plaintiff. What we have here is a case where the plaintiffs fully were aware of and understood that Shri Hotel Management Company was the operating entity for this hotel from the inception of their relationship with the defendants. They simply chose, for whatever reason, not to name Shri Hotel Management Company. To shift the burden to the defendants then, to say, well, in an answer, we should have raised there was another indispensable party which does have some common relationship and ownership, is to convert the defendants into their brother's keeper. It's not an indispensable party under the rules here. Most of the time when you see an indispensable party, there is some sort of right that is going to negatively affect the unnamed party. And that's not the case here. What we have are the plaintiffs complaining that their right has been adversely affected because the defendants did not somehow bring in a party that it was their responsibility to bring in from the beginning.
Run the risk of having happen exactly what did happen by not pleading this defense and not bringing in the party?
We don't believe so, because we believe that appropriately considering the facts and applying the law to the record that was developed in this case should lead to exactly what we're here asking for today, which is a reversal of the unjust enrichment judgment against Lotus and Mr. Patel through the veil-piercing claim.
Ask a question I asked again earlier because I think it really is important. Can you point to me where in the district court ruling this issue with Shree was addressed?
It was raised in the briefing where we specifically argued under the facts of this case, the plaintiffs had not adequately supported their claim that Lotus had received a benefit through which the unjust enrichment claim can be hinged. And that is because the benefit was received by Shree Hotel Management Company, the operating entity for the hotel itself. Now, the district court clearly considered that and rejected it because his finding was that Lotus and Mr. Patel had received a benefit. Now, we believe that that is what preserved error in this case. The only requirement is that the issue be raised and ruled upon. The unjust enrichment claim was certainly ruled upon, and the argument was made in our briefing.
So why is that finding wrong? I mean, if I understand correctly, Lotus Hotel Group owned the property that the hotel was on. It was getting money from the operating entity to be helping to pay for the mortgage and such. Like, why was it not benefiting from the services that the plaintiffs were providing to keep the hotel operating?
And the answer to that is because the relationship is too tangential at that point in time. If we had had a situation where the hotel was owned by one LLC, which serviced the bank loan and also provided the management and the day-to-day operations, we certainly would not be here today. But what we have is a situation where there were two separate entities formed for two distinct purposes. One was simply to hold the real estate and to service the bank note. The other was performing those management functions, the day-to-day operations. Now, if we are going to expand this now and say that we can hold a company liable because it has some financial relationship, it's going to completely widen the net of what we're considering in terms of who receives a benefit for unjust enrichment, particularly when you have an LLC that is much more directly receiving that benefit that simply wasn't named in this case. There's simply a better, more direct relationship between the operational entity and the plaintiffs here than the real estate holding company. And I think something else that's important with this argument is in the record, in the citations that we provided in our briefing, the plaintiffs, the appellees here, they were fully aware of which entity was providing what services. They were themselves agents of Shree when they became managers of the hotel. They became authorized to use the bank accounts, to use the credit cards. They were authorized to pay the payroll.
Certainly points at the testimony, but I'm looking at the district court's ruling and the credibility findings, and certainly the court thought basically everybody was lying about something in this case and discounted some version of, I think, every witness's testimony. Would you agree with that summary of the ruling?
I do agree with you that the court did find some credibility issues on all sides. I think where we would parse that a little bit is that we don't believe the credibility issues with respect to Mr. Patel, which is what it all centered on, and in terms of the some of the sorts of paperwork and how the entities were represented and things like that. We don't think those are particularly relevant to these issues because the facts still don't support being able to reach Lotus for the unjust enrichment, being able to pierce the corporate veil here. And just to pivot slightly to that piercing the corporate veil issue, which I do think is important, the appellees were relying primarily on some purported misconduct of Mr. Patel, which the district court did note, and again, he noted it on both sides of the case here. However, to pierce the corporate veil, the Supreme Court has said is an exceptionally high burden. And to do it on this record, where Mr. Patel was only ever holding himself out as an agent of the Shree Hotel Management Company or as a member of Lotus, to pierce the corporate veil and get to individual liability as to him, it eviscerates the protections that are ingrained in the LLC statute. The statute specifically provides that failure to observe formalities is not enough to actually reach a member. What we have to have is entities that are a mere sham, something that is primarily the purpose is to promote fraud or injustice. Under the facts of this case, that's clearly not what the situation was. The hotel room
Essentially find it was kind of a shell game as to what was going on.
did actually. I think what the district court found was that there were some questionable things happening with respect to PPP loans, which, again, we do have to keep in mind that this was in the midst of COVID. These were not intuitive systems. Mr. Patel gave some testimony about that. But what the issue is, though, is that we can't have piercing the corporate veil for somebody who was operating as an agent of this entity. The hotel is still in operation today. The management service company is still providing the services. The Lotus is still servicing the bank loan. If it was a sham, this entity would not be operating as an actual business. I'm sorry, I'm out of time,
Conclude your thought.
Your Honor. The hotel itself continues its operation. It is a legitimate business, and there's really nothing in the record to suggest that it was solely or primarily in the business of promoting fraud. Thank you.
Have 5 more minutes on rebuttal if you so choose. At this time, Mr. Sease, are you prepared to proceed? All right, whenever you're ready, counsel.
Your Honor, may it please the court. As mentioned, my name is Matthew Sease, and I'm here on behalf of Qube Hotel IA, LLC, Dharmenda Amin, and Dina Patel, no relation to Chetan Patel. Today, we are actually asking the court to also reverse the district court, but for vastly different reasons than what the appellants are. We're asking that the district court decision regarding the breach of contract be reversed, and alternatively change the damages award that happened in this case. But I want to start with the arguments, specifically what you raised, Judge Buller, about error preservation. The error preservation in this case regarding the appellant's arguments for the unjust enrichment claim, I don't think have been preserved in this case in any way. As you point out, Judge Buller, I don't believe there's anywhere in here where Judge McAllister addressed Shree's involvement and whether or not Shree was the sole party that was unjustly enriched in this case. This issue wasn't raised at summary judgment. It wasn't raised in trial briefs. It wasn't raised in the directed verdict. It wasn't raised in a 904 motion. The first time that this was addressed in any way was in their post-trial hearing filings, and then primarily through these appellate documents. And I think that completely violates error preservation for the court now to rule that, hey, Shree is the actual party that was unjustly enriched in this case. And I would point out that I just don't think that was true. I think that Lotus Hotel Group and Chetan Patel were the parties that were unjustly enriched in this case. My clients had no communications with anybody that is listed as an owner, has a membership interest in Shree Hotel on any kind of legal documents anyways. We have, what happened was Chetan Patel came in and he testified, well, I'm a silent owner of Shree Hotel, but I'm not listed on any documents. The ownership interest in these companies changed in the wind. And you saw Judge McAllister reference that in his briefs, that this was done primarily, the ownership structure was done primarily at the direction of Chetan Patel for his financial or tax benefits. You'll see at sometimes at tax returns, it's listed that there's a 95.5% ownership. On the PPP information, it's listed as a 50-50 ownership. When he later, after my clients are removed from the property, sells the property, he's now listed as a 100% owner in both Lotus Hotel Group and Shree Hotel Group. This is exactly why we have veil piercing in the law, is to prevent this type of issue. And there's lots of talks and discussions about in the appellant's brief about Iowa Code Section 489.304, where it says we can't hold LLCs liable for merely not following corporate formalities. That's not what happened in this case. Certainly it is true that they didn't follow the standard corporate formalities of having meeting minutes and annual meetings and things like that. But that's not what the basis of our case was. The corporate formality problems that happened in here were these ownership changes that aren't documented in any kind of meaningful way throughout this process. And the benefit was coming directly to Lotus Hotel and ultimately Chetan Patel. And that's what the district court found. Because without Dina and Dharm's work on this hotel for 3 years without receiving any money at all, there is no money that's coming in to service the debt of Lotus Hotel and to pay property or partner distributions through Lotus Hotel directly to Chetan Patel. So for all those reasons, if we lose on my arguments, we'd ask that the court affirm the district court on those issues. But I'd like to transition into my individual arguments about the breach of contract claim. And where I think the district court erred in this case was basically it all rests on the theory of ratification of the contract. There is no dispute in this case that the original draft purchase agreement in this case came not from my clients, but came from Chetan Patel. He sent that document to my folks. My folks edited it. There was email exchanges that were put into the record where that was discussed back and forth. There's no dispute that my clients sent the signed version of this to Chetan Patel. And he received it and didn't respond to it and object to it in any way. And then that happened at least 2 other times where the contract or versions of the contractual documents were submitted directly to Chetan Patel. And at no point did Chetan Patel ever say, hey, I don't have a contract with you guys. I don't have a contract. What is this document? And object to the fraud that they are now claiming happened in this case. And that's important because even if you adopt their testimony entirely of Chetan Patel and adopt and reject my client's theory that they had permission to sign these contractual documents on behalf of Mr. Patel. The restatement and the case law that we cited in our brief says even a forged contract can be binding on another party if they learn about it and ratify it and don't object to it in a meaningful way. And there's no evidence in this case at all until after the lawsuit was filed that Chetan Patel ever rejected the contract that was issued in this case.
Make of the district court's pretty detailed fact findings that there just wasn't a meeting of the minds in the first place. I mean, that seems like it's got credibility determinations baked into it.
I think that goes exactly to the ratification argument and what ratification is once Chetan Patel receives this document and he doesn't object to it, he has agreed to it and there is a meeting of the minds. So even if there isn't that meeting of minds at the time that the contract is signed, and we think it was rightfully signed by my folks when they had permission to do it, but let's say that that's not true. It's forged. And I think that there's the case and the restatement directly talk about that. If this document is forged by an agent of or another company, and then the company receives the contract and never objects to it, they do have a meeting of the minds because they've accepted that forgery or they've accepted that contract. And I understand and I appreciate what you had said earlier, Judge, that Judge McAllister had found that nobody was credible in this case. But what I'm talking about is undisputed evidence. These are email communications that were submitted to Mr. Patel, and he didn't object to them, and he didn't object to it in any way at all.
About what maybe is sort of a discrete fact finding that's, I think, coloring part of this discussion. Judge McAllister says that part of his conclusion for why there wasn't a meeting of the minds was these ongoing discussions, basically that in his mind, the negotiations never stopped. That it does seem like it's a fact finding supported by the record that I can't set aside. What am I to do with that in light of your argument?
I think it's somewhat inconsistent with what the actual communications were. There certainly was, and I think it's in the July 2019 time period, there's these email correspondences that go back and forth between my folks and the appellants folks, where they're talking about expanding this operation. And what you see in those email communications, specifically the one that comes to mind, I don't remember exactly what exhibit it is, Your Honor, and I apologize, but it's an email from Dina Patel, my client, where they outlined and said, okay, moving forward, we're going to possibly do this regarding Shree Hotel, and we're going to be a third owner of this and a third owner of that, and it's bullet pointed. And the last bullet point is that Qube Hotel Iowa is going to have to enforce the contract and operate under the contract and the agreement that we already had. And so what we have is discussion about maybe expanding this arrangement and going forward with a different arrangement than what they had before. But it's undisputed that at that time, my folks had been there for many months already, not receiving any money, not paying, and in fact, were pretty much exactly operating under the terms of the agreement and the contract that the parties had agreed to. And then, more importantly, when these discussions fail, they continue to do that for over a year or two, where they continue to work on the project, or not work on the project, but work at the hotel and not receive any compensation at all. So that's all consistent with the terms of the contract, and that they had that.
Winding down on time, I wonder if you could maybe just address the damages portion of your cross appeal and how we aren't stuck in the same discussion about fact findings.
Exactly. So for the breach of contract side of it, I think that the court should remand it and allow the district court to make that. I think the district court has to decide which expert they view is appropriate. I think the court would possibly have the authority to just look at our expert's testimony regarding that, but I think the appropriate remedy is to remand it down. The real issue that we have for the damages calculation are, first, that we believe that the district court erred in not adopting our expert's testimony, and that was supported by the evidence, and it was conservative. If you look at the evidence that was introduced of the prior ownership of the hotel, that was, I see my time's expired. Can I just finish my thought?
Yes.
Okay, thank you, Your Honor. If you look at the prior ownership history of the hotel in Exhibit 78, the prior expenses for employment and wages was actually higher than what our damages are requesting. So, thank you.
Any rebuttal?
Thank you. Just briefly to touch on the breach of contract argument, I do believe this is where the credibility of the appellees comes into play as well. Virtually every time in the record where this purported contract was sent to Mr. Patel and he seemingly didn't object to it was in connection with the appellees submitting their visa requirements. They were in a lengthy process to get the right visa application process going, to get the right credentials to be in the United States of America. Now, Mr. Patel testified at trial that he was not really involved in that process. That was something that they were doing. They were providing all of this documentation to the embassy and the consulate in furtherance of that. He testified he didn't even open these emails. Failing to object to an attachment where an email subject line is visa requirements. Here's our visa submission is far from ratification of a contract. And to that point as well, none of the parties ever conducted themselves as if there was a valid purchase and sale agreement. Because if that were the case, the appellees would never have been managing the hotel. They would have owned it. They wouldn't have been operating through Mr. Patel's entity, Shree Hotel Management Company. They would have been operating through Qube Hotel LLC, which was their own entity. And so we do not believe the ratification holds water, and we would encourage you to affirm the district court on that point. I do want to touch on the damages element of unjust enrichment, because the issue that we raised on appeal was that the district court erred in including within that damages amount $46,000 on an annual basis for appellee Darm Amin's bookkeeping services. We believe that Mr. Amin's own testimony fatally undercuts the fact that he was entitled to any sort of award for the bookkeeping services. What he testified to was that he essentially shuttled information to the actual bookkeeper and accountant that was hired for both Shree and Lotus. Mr. Amin testified, and all of these citations are in our briefing, that he was not even qualified to really provide bookkeeping services in this country because he is UK-based. He did have a financial background, but it was not in the United States. He testified that he didn't even feel competent to do that. So this was not simply sending documents to complete the annual tax return. He was sending monthly payroll. He was just collecting information and sending it to the accountant. He also testified that much of his job was not bookkeeping services at all, but was just the general management of the hotel along with his wife. He was making breakfast, he was turning down beds, he was cleaning rooms. And so we do believe that it was error to identify that $46,000 per year as additional services. The record is clear that Mr. Amin simply was not providing meaningful bookkeeping services in that regard. And we do have, touching on the point of Appellees' argument that they were entitled to some additional expenses, there is absolutely no citation in the record to anything to substantiate that any of those costs were actually incurred. They didn't produce anything but their own handwritten invoice that they created. There were no receipts. Nothing was submitted. In Mr. Amin's testimony, he even said, well, I could gather that, I could collect all that for you. But he never actually presented it. There's just nothing in the record to base an award of $100,000 or even more for the furnishings that the testimony was that the Appellees brought from their own home in the UK. And I think finally, with my very last minute here, I do want to touch on one additional point where, again, we urge the court to reverse the unjust enrichment award against Lotus and Mr. Patel. If the court does that, we do have to address the issue of conversion of the vehicle because the district court used that as an offset to the unjust enrichment damages. As we urge the court to reverse that, we do argue that the conversion needs to be reinstated for Mr. Patel individually because he is entitled to receipt of or return of those funds. So even if the unjust enrichment claim is wiped out, the vehicle is still an expense and a wrongfully retained benefit that the Appellees kept that does belong with Mr. Patel. And I will stop there unless there's a question.
Thank you, counsel. Thank you both for your briefs in this matter, as well as for your arguments here this afternoon. We will consider this matter submitted, and we will get a ruling out as soon as we are able.